Hi, welcome back, Attorney Steve Vondran. Welcome to another exciting episode of Litigation Warrior. Okay, so we're talking in this video about MIDP, Mandatory Initial Disclosure Project. Now, this is going to arise, as it says here, in Arizona, federal court, not state court, federal court. So a lot of people know that one of the big differences between state courts and federal courts, in federal courts you have what we call these Rule 26 disclosures. These are the disclosures that you have to give in the right when a lawsuit's filed. You know, pretty early on in the case, you're going to be disclosing to the other party what your key facts are, who your witnesses are, what your documents are, your damages, those kinds of things. But Arizona, I would say, took it one step further. And I think this is a way to try to ferret out cases and unclog the courts and make cases settle faster. That's just my 2 cents on it. But it's a mandatory initial disclosure project. And I have a little sample here of one that I have in a recent case. And it's a pilot project is what it is. Effective May 1st, 2017, this court began participating in a mandatory initial discovery pilot project approved by the Judicial Council of the United States. So what it is you get in, you file your complaint. The plaintiff is going to have a duty to serve the order, General Order 17-08, and they're going to have to serve that order along with an MIDP checklist. And I don't know if that checklist is in here. It is. You can just take a little look at it. This is a little checklist, a checklist of things that's going to come with the case, and you need to let the other party know that this is the MIDP program. Here's a checklist of things you need to follow, the things you need to disclose, and if the judge has any special orders in either a case management order or in an MIDP order, then you need to follow what it says in the order. So that's where you always want to look first, is to the order itself. What does it say? What do you need to disclose? So I'm going to go over just real basic what this is. And here's the order. This is the general order that gets disclosed. And this applies if you file a counterclaim or a cross-claim against another defendant. As the party seeking affirmative relief, you need to serve the general order and the checklist. Okay, so that's kind of how it works. So basically, there's different things that you're going to disclose. I would say it's very similar to the Rule 26F disclosures that you make. And I would say the cases I've been involved in, generally, it seems that these MIDP disclosures are due within 30 days of the answer being filed, okay? Within 30 days of the answer being filed. So, but again, this is general legal information only, not legal advice. Make sure you check your rules, check your judge, check your court, see where you're at. So here's some of the things it says. As I mentioned, any party seeking affirmative relief must serve a copy of the notice. The parties to this litigation are ordered to provide mandatory initial discovery responses before initiating any further discovery in this case. So you can't just go and start sending out requests for special interrogatories, setting depositions. This has to come first. Okay, so that's just the way it goes in federal court here in Arizona. The responses are called for by the court, not by discovery requests actually served on an opposing party. Part B of this order sets forth the categories of information that must be provided. So I'm just going to go right into that Part B and get to the meat, so to speak. The parties must respond to the following court-issued discovery requests without awaiting discovery requests from the opposing parties and at the time set forth above. So number one, you need to state the names and, if known, the addresses and telephone numbers of all persons who you believe are likely to have discoverable information relevant to any party's claims or defenses, okay? So names and addresses, people likely to have discoverable information. And provide a fair description of the nature of the information each party is believed to possess, okay? So that's one requirement that you're going to put down. Number two, names, addresses, telephone numbers of all persons who you believe gave a written or recorded statement. A written or recorded statement relevant to any of the parties' claims or defenses. Number 3, and I'm skipping over a few things here just to keep this video short. Number 3, list the documents and the electronically stored information. That's ESI for short. List the documents, electronically stored information, tangible things, land, or other property known by you to exist, whether or not in your possession, custody, or control, that you believe may be relevant to any party's claims or defenses, okay? So those are your documents and your electronically stored information, okay? That's your text messages, your emails, things like that that are stored electronically. Include in your response the names and, if known, the addresses and telephone numbers of the custodian of the documents, whoever has it, or the custodian of the ESI or tangible things that are not in your possession, custody, or control. Okay? For number 4, for each of your claims or defenses, state the facts relevant to it and the legal theories upon which it is based. So this is kind of interesting. So like in state court cases, you can file a suit, you can get involved in some discovery, you can take some depositions, and then you can sort of, claim your facts and theories and see what they are, and then formulate your legal theory. But in Arizona, under the MIDP, you need to get that out up front, what you believe your claims and your defenses are right off the bat, and the law that supports it. Okay, so you're going to need to be citing and quoting some relevant law to the extent that you're aware of it. Number 5, provide a computation of each category of damages claimed by you and a description of the documents or other evidentiary material on which it is based, including materials bearing on the nature and extent of the injuries suffered. So you need to document your damages to the extent you know them, right up front in this lawsuit, okay? So just bear that in mind. So when you think about filing a suit in Arizona, say you're going to file a copyright infringement lawsuit or something, real estate related or whatever the case may be, you want to make sure you have a good idea what your damages are, how you're going to document your damages, your legal theories, your witnesses. You see where this is going. Number 6, specifically identify any insurance or other agreements under which an insurance business or other person or entity may be liable to satisfy all or part of a possible judgment in the action, or to indemnify or reimburse a party for payments made by the party to satisfy the judgment. So they want to know if you have any insurance. Are there any parties that are going to be obligated to pay, or somebody you would tender the defense to, that kind of thing. Okay? And number 7, a party receiving the list described in paragraph 3, the description of materials in paragraph 5, blah, blah, blah. DDD, so let's skip over that. Disclosure of hard copy documents in ESI. This is your electronically stored evidence. This is a big part of it, is your hard copy documents must be produced as they are kept in the ordinary course of business. And as to the ESI, the electronically stored information, there is a duty to meet and confer, to meet and discuss with the other party what you think the kind of evidence you're going to have, how it's going to be disclosed, what format. It's got to be, something that everybody can understand. It's easy to search. So, we're not just spitting out a bunch of computer data that nobody can read and understand, okay? So there's information on the ESI. If there's any other disputes, any other issues, those are the kinds of things that you want to bring to the attention early on. Now, what happens basically when you're engaged in this MIDP is you give the disclosures to the other party, and you're just filing a notice with the court, not the actual discovery documents or your damages or your witness list or anything. You're not disclosing that to the court, but you do have to let the court know that you have filed and satisfied the obligation as to the MIDP. You file a notice under a certain category in your online federal filing system, and you let the court know that you did your filing. The other party will let the court know as well. And then you also have a duty to supplement. So every 30 days or whenever you find new information that's relevant to the case, you have to update it. Okay, and so once all this is done, then the parties can engage in your essential rules 26F discovery, your FRCP 30, 60, and 45 discovery steps. And that's pretty much how it goes. So in Arizona, this is the upfront process. This is a pilot project. I believe it's going for 3 years. So I guess it's going to 2020. And there'll probably be some evaluation and people will chime in on whether they like it or not. For me, I kind of like it. I think it's good to get the theories out there. It's just kind of an add-on to the Rule 26F disclosure obligations, and they just come, pretty quick in a case. So aside from that, that's a general overview. This is not legal advice. Read your orders closely. Read the initial disclosure document. Read those and make sure you understand the rules. As to the disclosures, your parties need to review the disclosures and sign them under penalty of perjury. The attorney is also signing under Rule 26G FRCP, basically that there's been a good faith, reasonable, diligent search, and that you're disclosing the information that's reasonably available to you at the time of filing, okay? So again, it's putting your cards on the table in Arizona. That's how it goes here. And when you get to the joint report that you have to file out, Rule 16 joint report or case management report, usually there's going to be a requirement to discuss the MIDP and whether or not there were any issues with that. So it is an issue on the judge's radar, probably comes up early on in a case management conference. So make sure you're doing it, make sure you're aware of your obligations, and read those rules. Make sure you understand what the court's looking for. Okay, that's about it. I hope you liked this video. Attorney Steve Vondran, licensed practice law in California and Arizona, social media, intellectual property, and real estate law. If you have any other questions, leave them here in the comment box below. Please don't leave any personal information in there. And if you like this video, subscribe and feel free to share our videos on your social media networks. Attorney Steve out. I got to get running. Got lots to do. I hope this has been valuable for you. Thanks a lot.